All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in CV140319. Is it Naima? Naima versus 4. We are recording today's proceedings, so counsel, when you step to the podium, if you would please identify yourself and the client you represent. Each side will have 20 minutes for oral argument, and Mr. Sparks, as the appellant, you're responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs. We have conferenced the case prior to this argument. So with those preliminaries out of the way, Mr. Sparks, you may proceed.
Good morning, Your Honors. My name is James Sparks. I represent the appellant, Felicia Naima. This is a case involving a motor vehicle crash that occurred in November of 2011 between the plaintiff, or appellant Felicia Naima, and the appellee, Jeff Four. Felicia was injured in the crash. Following the crash, she received treatment from the hospital, a chiropractor, and eventually a pain management specialist named Dr. Patrick Hogan. This matter proceeded to trial in January of last year. During the trial, Dr. Hogan testified through his video deposition that Felicia would need ongoing medical treatment and gave an opinion as to the necessary future medical care and the cost of that care.
Has she been receiving ongoing medical care?
Is she at this time, Judge?
Well, at that time.
At that time, she didn't have any treatment scheduled. Unfortunately, her finances did not allow for it.
And I think, following up on Judge Howe's point, one of the factors that seems to distinguish this case from some of the others that have been cited is the fact that Dr. Hogan, as I recall, at the time of trial hadn't seen your client in about 17 months, which creates some definite issues about the burden of proof on damages in my mind. Talk to us about that, why that's not a problem.
It's not a problem for one reason, it wasn't a problem for Dr. Hogan in giving his testimony, which was just probably about two weeks approximately. It was very shortly before trial. And it wasn't a problem because there are various reasons why Felicia might not have gotten ongoing medical treatment. And again, it was because of finances. Those sometimes aren't issues at trial, and I don't believe it was necessarily raised other than it had been pointed out that she hadn't been there in some time. However, Dr. Hogan also did provide testimony that these particular types of treatment, these spinal injections, they can last anywhere from a couple months up to, I believe he said, 2 years. So it really wasn't that much of a problem for us because the treatment did work for a substantial period of time. It was several months before trial, but not a significant time before trial, that her pain did in fact return. And that ultimately, I think, is what distinguishes this case from the Griffin case, which according to we submitted the transcript, it was clear and expressly stated, indeed, that the trial court relied on the Griffin case in finding that, in the Griffin case, the doctor testified that it was the symptoms that would drive the need for future medical treatment, and there was no testimony, and the Griffin court specifically pointed out that there was no testimony that the symptoms would in fact occur again. Now, of course, no one has a crystal ball. Sometimes the treatment that Dr. Hogan provides does work, and they don't need future care. However, Dr. Hogan expressly testified that in his professional medical opinion, based upon his experience as well as the literature, that Felicia would need future medical treatment. It was that laid the foundation that met the plaintiff's burden of proof on the future medical care. At that point, it was an issue for the jury. It was no longer contingent or speculative. And of course, it was still contingent. Dr. Hogan said, we need to examine her. It's going to be her symptoms. Indeed, I think that testimony is not surprising, and you will probably be skeptical if a doctor didn't say that. It's simply unimaginable that a doctor would not want to examine a patient in the future if he's prescribing care.
But what if it had been 3 years since he'd seen her? I mean, there has to be, it seems, some sort of temporal link that makes the opinions about future care non-speculative. I mean, I think we'd all agree that if she hadn't seen him in 10 years and he came in and said this, well, that's way speculative. But so where do we draw the line? 17 months seems like a long time, and it seems different from every other case. I mean, Griffin, which you just referenced, the doctor had seen the plaintiff a few months before trial. And so that's an aspect of this that I'm finding troublesome.
I would say, Judge, Dr. Hogan didn't examine Felicia right before trial or in the couple months leading up to trial. His opinion was ultimately formed before that point. And, doctors don't exactly, I mean, there are disclosure requirements and stuff like that. Doctors don't exactly examine the plaintiff the moment before they walk into the courtroom. They give their opinion, and if something arises between that time and the trial, certainly it goes against the credibility of the doctor's opinion. But it doesn't mean that the foundation hasn't been laid for his opinion.
Let me ask Judge Downey's question, but focus in on what Dr. Hogan had to say. For example, I'm looking at his trial testimony, and would be at page 39 of the transcript, which in the opening brief would, in fact, be PDF 52. But he says, the question is, why do you believe Felicia will need the future care you just spoke about? And then his response is, well, like I said, these nerve blocks are essentially temporary, so this pain typically returns at some point. And so her symptoms will be the main thing that would tell us if we need to repeat the procedure. Now, there's additional testimony, but from that, I look at that and I go, okay, her symptoms will drive necessity for future treatment. But he hadn't seen her in 17 months or so. So how could he then continue to say she is or is going to be symptomatic? Mm-hmm. And then when he says are essentially temporary, I understand he's making that statement based on his clinical experience, but doesn't it have to be doesn't his testimony of reasonable probability have to be linked to his examination of the patient rather than what I see typically? So that's kind of 2 points there. And those are, I think Judge Downey asked it better than I do, but those are my concerns.
Whether it needs to be or doesn't need to be, I think depends on the facts of the case. And I think that if, in this case, Dr. Hogan had never examined Felicia at any point, it probably wouldn't be a particularly credible opinion because the opportunity was there, certainly. In this case, though, Dr. Hogan did examine her, treated her. The pain returned, and then he treated her again, I believe, or at least examined her again. And it was that information, the fact that her pain did return at least once after his examination and his treatment, that caused him to believe she would continue to have pain again in the future.
So perhaps what you're saying is, I believe he testified that he had treated her, at least I thought, maybe 2 or 3 times in 2012, and perhaps once in 2013. And so because she had been an ongoing patient, although sporadically, but nevertheless ongoing, that was perhaps additional evidence?
Well, that is correct, yeah. And there is a point, I believe I referenced it. And this was it's cited to on page 2 of my opening brief, but he stated, and she's had it, by the time she saw me, she had it for 5 months. So, I don't think it's necessarily going to go away. And so he did take into account how long the pain has been present when he issued his opinion. And, ultimately, as far as laying the foundation for expert testimony, it can be based upon facts that aren't necessarily, within the personal knowledge of the expert. The expert can provide, and often do provide, opinions based upon facts that they don't have personal knowledge of. Now, of course, if those facts turn out to be inaccurate, maybe the opinion's inaccurate. In this case, there was testimony at trial that Felicia was still in pain. And so, of course, if someone said, hey, doctor, it's been 5 years, 10 years, and obviously you're wrong, her pain hasn't returned, then I think maybe the testimony should be excluded. But this is not outside the scope of what Dr. Hogan testified was possible. He said that these injections can last up to 2 years. And certainly it had been less than that time since he'd last examined her before the trial.
But you just used a word there that I don't think you really meant to use, which is possible, because possibility certainly wouldn't be enough. So we've got to find more likely than not, reasonable degree of medical probability. So do we have that, or do we have possibilities?
We have that. We absolutely have that, Judge. And it's on, I say it's on page 2 and 3.
I was just trying to clarify your argument, because
Oh,
you just talked
sorry.
about possibilities, and so I'm trying to make sure that's not what you're really trying to buy, is a possibility.
No, and I'm not. Ultimately the testimony was not just that it's possible, but that it's highly likely and probable that she will have ongoing symptoms and need ongoing care for the rest of her life.
That's what I thought you were arguing, but I needed to make sure.
Thank you, Judge. And that, again, is in the testimony and expressly distinguishes the Griffin case from this case, because that testimony that was missing in that case was, in fact, provided here. And so for that reason, we'd ask that the matter be remanded for a new trial. If you have any other questions, I'd be happy to answer them.
No, you have time left for rebuttal, though. Thank you.
Thank you.
Mr. Alaga?
Good morning, Your Honor.
Good morning.
Good morning. My name is Sam Alaga, and this is my colleague Christy Woods, who is not sitting at the council table because she's not on the caption. We represent the appellees, Jeff and Terry Forer, in this case. This case is more compelling than Griffin for some of the reasons that Your Honors mentioned. A reading of the trial court transcript as it pertains to the issue of future damages showed that the trial court, the trial judge, took into consideration all the facts, all the testimony, the relevant testimony of Dr. Hogan, applied the correct case law, being Griffin, and ultimately made the right decision. Now, what we have here is an accident in 2011. It's a relatively minor injury accident, but evidenced by the fact that Ms. Naima self-reported to the emergency room, and she was not she did not have to undergo any sort of diagnostic testing, and she was just given pain meds and let go. There was no diagnosis at the hospital. So that's an important factor. She started treating with a chiropractic who then referred her to Dr. Hogan. And it's important to know that the chiropractor, in his notes, he essentially authorized Dr. Hogan to give pain medication, injections to this plaintiff. Dr. Hogan himself has testified, has admitted that he gave the injections, the initial injections, without really evaluating plaintiff, without reviewing any medical records. I shouldn't say evaluating. He did talk to her, but without reviewing the medical records and any diagnostic imaging, and only based on plaintiff's complaints of pain, which he himself admitted is always subjective. Now, based on those two or three from April 16 to May 4, 2012 injections, that's the last that Dr. Hogan saw this plaintiff. He testified the plaintiff missed an appointment, a follow-up appointment, on September 28th of 2012. And I'll talk about her reasons for doing so. 17 months after, Dr. Hogan testified at trial, and I think the gap in the time between Dr. Hogan last seeing plaintiff and his trial testimony is absolutely a problem for plaintiff's burden of proof regarding future damages here.
Let me clarify the timeline. So you mentioned a September 2012 appointment that was missed, and is that the last time the record suggests the plaintiff was scheduled to see Dr. Hogan?
That is my understanding.
Forgive me, I thought, and I guess we can drill down again, that she had seen Ms. Nima, forgive me for, may I call her Felicia?
Absolutely.
Without any disrespect. That Felicia had seen Dr. Hogan once in 2013, and that he had wanted to do a different type of procedure, but apparently the insurance company wouldn't pay for it.
I haven't seen that. I may be wrong on that, Your Honor, but I haven't seen it. My understanding is that the May 2012 visit was the last visit. And if there was a 2013, I know that there wasn't any sort of procedures that took place at that time. However, Dr. Hogan most importantly testified 17 months after the last treatment, and his testimony is crucial in this case, and Judge Flores took that into consideration. He specifically said that, and maybe this is why I'm confused, because his testimony was that Felicia has not been back since 2012, and he has no idea if she ever will come back. No idea whether she continues to have pain at the time of trial. No idea whether those initial injections were effective. No idea what type of pain she may have, if she does in fact have pain, whether it's nerve pain or joint pain, which would dictate what sort of recommendations he would make as far as whether epidural injections or nerve ablations. He did not know any of that. And most importantly, he said future treatment is always based on a patient's symptoms, which he did not know at the time of trial. He agreed that it would be pure speculation for him to recommend any sort of future treatment when he was asked, especially if a long time has elapsed, which he admitted there had been a long time. So the gap in the last treatment and Dr. Hogan's testimony shortly before trial is absolutely a problem when it comes to plaintiff and their meeting of their burden of proof. Dr. Hogan did not know what sort of treatment this plaintiff would require, again, because he had not reviewed, he had not had a follow-up with her. And most importantly, or I shouldn't say most importantly, but also as importantly, is that there was no testimony, there has not been any testimony presented regarding for how long this treatment would be required. And that's absolutely, that goes both to the cost of the treatment, the future treatment, and also whether it's reasonably probable that treatment will take place. There was no testimony whether by Dr. Hogan or anybody else whether plaintiff would require one more injection, two more injections, or injections for life.
Let me just interrupt because I don't usually bring trial exhibits into the argument, and as walking in, Judge Norris asked me why I had them. I said, I don't know, but now they're useful because we do see medical records that show that she visited Dr. Hogan in 2013 on one occasion. So just to clarify the timeline, there was still a 17-month gap between the last visit and the time of trial. I recognize that. But as long as I'm talking, I hear you making two arguments about future medical care. One is that there's not a fact of damages as to that, and second, the quantification of those damages is speculative. Are you making both arguments? Because the fact of damage has to be established with more specificity than the quantification of damages.
I am making that argument, Your Honor. I think they damage the amounts. The quantification also goes to the reasonable probability as well, because this is not a situation like in Griffin when there was only an issue of one surgery, whether this surgery will take place or not, and we know the cost of that surgery. Here we have a treatment that may have to be repeated for every 6 months to 2 year interval, and we just don't have any evidence put forth by anyone about for how long reasonably is it necessary. Is it reasonably probable that this treatment will continue for the next 2 years, 5 years, or for plaintiff's life expectancy? And that goes to the issue of quantification as far as the reasonable costs, which has to be established with reasonable certainty. And it also goes to the issue of whether future medical treatment is reasonably probable, at least in years 2, 3, 4, until the rest of plaintiff's life expectancy.
At pages 136 and 137 of the deposition that were read to the jury, Dr. Hogan explained and stated that based on his clinical experience and experience as a doctor with these types of conditions, that although no doctor can predict with absolute certainty, so we understand that, but he said and stated, but doing this every day, seeing these patients, seeing how they respond, certainly there's a high likelihood that she's going to require, ongoing treatment. And those options would be repeated epidurals, radio frequency ablation, She has treatment options available to her. I hope she never needs them. But we go by averages. We go by our clinical experience. And that's my opinion, that she'll need some ongoing care at some point down the road. Okay. And then earlier, he had explained again that she had a permanent condition. The bulges that were causing the pain were not going to go away. Again, looking at all of his testimony, why does it come up? I'm just having a hard time putting cost aside. Why does it come up short? When you look at all of it, that it doesn't show that he gave an opinion to a reasonable degree of medical probability that she would need future treatment.
I guess my best answer to that, Your Honor, would be because it was not specific to this particular patient. The testimony of Dr. Hogan, and I think what you cited, Your Honor, was the best testimony that would most support plaintiff's position. But there's plenty of other testimony from Dr. Hogan. Well, he specifically said it would be speculative. I know this literature. I know based on my clinical experience of what I do see. But the most important factor is a patient's symptoms, which I do not have. And I think that overrides the literature that he may have been talking about. He did talk about permanency, but he also admitted he doesn't do permanency rating and that he's not qualified necessarily to offer that. Of course, permanency itself is not a dispositive of the issue of future medical care. I think one sentence in page 35, lines 18 to 21 of Dr. Hogan's testimony and summarizes this case very well is, he says, if plaintiff wanted medial branch blocks, the average would be every 11 months with a range of somewhere between 6 months and 2 years with an average of 11 months if those symptoms returned. So there's a lot of ifs. One, if those symptoms returns, which we do not know if they did. Two, if plaintiff wanted medial branch blocks, which Dr. Hogan did not know at the time of trial whether she wanted to. Now go to the issue of whether this plaintiff, whether there's any evidence that the plaintiff at the time of trial desired this medical treatment. And plaintiff has argued that there was trial testimony that she had pain. What's important to recognize is that the only thing that we have in the appellate record is the testimony of the plaintiff, which was given on November 8, 2012 in a deposition, which was read to the trial jury. So in November of 2012...
I'm sorry, forgive me, I was taking a note of a point you had made. Did you say that her deposition testimony was
November 8th, 2012.
And that was read to the jury?
I believe so.
Okay.
Yes, Your
Well,
Honor.
that's kind of an important point. Do you know for sure?
I know it was read to the jury since I wasn't trial counsel. I don't know if she actually also testified on top of that. None of the transcripts of her, any trial testimony aside from the deposition are in the affidavits, and I haven't seen it from the documents I've received from trial counsel.
It's just that the minute entries were pretty specific when a deposition was read to the jury, and I don't recall seeing that, and it may be an important point, so, but you feel certain that it was read to the jury? From appellant's reply brief, if you look at that, they say that they... It was filed with the court, but that's a completely separate issue. It's filed with the court, but that doesn't mean it was in front of the jury. So, but maybe Mr. Sparks can tell us the answer to that.
Yes, Your Honor. But that is the only testimony from the deposition that is on the appellate briefs now. And in November 2012, shortly after she missed her appointment, the follow-up in September, she testified that she did have pain at that time. She testified that she was apprehensive about receiving this treatment because she had heard somebody had died from it. But at the time of the deposition, she said, well, one of my friends is convincing me to go ahead and get the procedure, and that I'm going to make an appointment next week. Well, she didn't make an appointment next week, and she never had the treatment done from November 2012 until the time of trial.
What about the doctor's testimony that she visited with him, I think it's March 2013, and they discussed this particular form of treatment, and she was not, well, maybe that was in December, she was not approved for that treatment.
And I think that certainly goes to whether she desired the treatment at some point back in 2013. There's no denying that, Your Honor. But the totality of circumstances have to be taken into consideration according to case law that I think both us and the appellants agree with, which is Besh v. Triplet. And the totality of circumstances are that we have a procedure that the doctor has described as very invasive. He has described that some people get the procedure once because there is a injection next to their spine and they never come back for it. We have a plaintiff that has expressed apprehension about getting it because she is afraid of dying from it. She has then said that she's going to make the appointment at some point in the next week, and there's a 2013 visit, but she never actually got the treatment.
But, you know, the argument you're making right now, to me, sounds like going to the weight of the evidence and not its admissibility. I'm not, again, if Dr. Hogan had the ability to say with some foundation that she was going to require future care, then the specifics of what would be required, it seems like, was for the jury to weigh. And so I still think that threshold issue is the one that we have to get past, and frankly, maybe your stronger argument is whether he had the foundation to testify as to future needs at all, setting aside the specifics of what those would be.
Your Honor, I think you're absolutely correct, and that is the stronger argument, and I think we recognize that. But I think there is an additional argument that plaintiff had the burden by totality of circumstances to present evidence that she actually desired the future treatment at the time of trial. And that's lacking, as well as the foundation of Dr. Hogan, which
But
is...
that wasn't the basis, was it? That particular point was not the basis for the motion notwithstanding, forgive me, I'm old school, the motion for directed verdict, which I know is not its name. But that wasn't the basis for the motion, was it?
They, and Judge, the Rule 50 motion, it was actually a written motion, is in the
Right.
file. I don't think that there's emphasis on that in the motion, and you may be correct that it's not mentioned there at all. But I do think that these issues are interrelated. I think the focus was on the stronger argument, which is Dr. Hogan did not have the foundation to offer the testimony, which, and he did not offer the testimony. Not only did he not have the foundation for it, but he didn't offer it. He did not provide sufficient testimony that by reasonable probability future treatment would be necessary. He said the magic words, but the magic words alone don't overwrite the substance of his testimony. And the substance of his testimony over and over and over again was he needs to see this patient. He needs to see her first before he can recommend it. So how can he say it's reasonably probable for her to have future treatment without having seen her, without any follow-up appointment, without even knowing if the initial, if she still continues to have pain? And that's one issue that the court, and this court in Griffin, specifically commented on. The ruling was essentially that in Griffin, there was a portion of the transcript, the minute entry, or the ruling that says, it is well to note also that there is no testimony that plaintiff's condition would or might increase or worsen in the future. And that testimony also is lacking in this case. And that's crucial. And again, as I mentioned, also there's, I presume, I don't know for a fact, but I presume that plaintiff would seek to admit a life expectancy chart and argue for this treatment on a 6 months to 2 year basis for the remainder of plaintiff's life. But again, we don't have any testimony that reasonably this treatment would be probable for the duration of the plaintiff's life. We don't have any testimony.
In fact, the mortality tables were given to the jury based on the claim of future pain, suffering, anxiety, disfigurement, et cetera. So that, I mean, that information, the court did allow future pain, suffering, et cetera, to go to the jury. Does that?
Well, and I only assume, and that's my basis for presumption, that plaintiff would seek to have the cost of future treatment for the injections, for also the expected life of plaintiff, and I think that is also very problematic because of the fact that we don't have any testimony at all that reasonably this treatment would be reasonably probable for the duration of plaintiff's life. We just don't have anything like that, as noted also in Griffin. That was an important factor in that case. And it is in this case. I do think the facts of Griffin and this case are substantially similar. I do think this case is more compelling in that we have a period of time, a long period of time, where Dr. Hogan has not seen this plaintiff, which was not, it appears, was not the case in Griffin. And in Griffin, we dealt with one surgery. So if she needed it, if the plaintiff, he needed it, it would be one surgery. We knew the cost of it. Here, we're more speculative than that. We have a treatment that may have to be repeated, and we just don't know for how long. For those reasons, Your Honors, I think that Judge Flores made an absolutely correct decision based on the facts and the case law that was presented to her, and we ask the court to affirm that decision.
Thank you.
Thank you.
And rebuttal, Mr. Sparks? Can you clear up the issue, whether it matters or not is another issue, but do you know where in the record we could determine that the plaintiff's deposition was read to the jury at trial? Or is that your recollection that it was? Or?
I don't know if it was or not, to be candid.
That's
I'm
fine.
pretty sure I asked her, though, those exact questions.
We don't have the trial transcript is the problem.
And the reason is quite simple. It wasn't raised as an issue at trial, nor was it in any of the motions leading up to that. It was presented for the first time in the responsive brief.
Yeah, I get it.
And it wasn't raised because that testimony was absolutely laid at trial. And as far as the length of time between when Dr. Hogan the length of time as far as how long she's going to need the treatment for, again, the mortality tables were given to the jury, and on top of that, that again wasn't an issue at trial. I don't even think that was in the answering brief. That wasn't until right here, right now, that issue was presented. Issues raised, was she in pain at the time of trial? What does it matter? You know, Dr. Hogan's deposition was just shortly before trial, and Felicia was not in the deposition room testifying then, so all he had to go off of was what he knew from his prior examinations, his experience, and his education, and he still gave the opinion he gave.
Well, but now, we have a bit of a handicap because we don't have the trial transcript, but if, for example, hypothetically, she was not suffering from additional pain, that would have been, and she had said that at trial, that would have really undercut his testimony because he was very clear that the pain, the symptoms, drive the necessity for medical treatment. Mm-hmm. And she said, you know, it's been great. I've been pain-free for the last 12 months. I mean, so it's an important fact. Mm-hmm. And I don't think it's something just because he testified a couple weeks before trial doesn't change the timing problem that we've been raising.
And I agree that would make his testimony certainly lacking in credibility. I don't know if that doesn't mean that he doesn't have the foundation to give the opinion that he gave.
No, I mean, his opinion was based on what he saw and at the time, but it was grounded on she was going to have symptoms. And if she had testified at trial, she's not having symptoms.
And a variation on what Judge Norris is getting at, as I heard Mr. Alaga argue it, basically Dr. Hogan specifically and inferentially stated several times that symptoms drive the need for future care. And so if he hadn't seen your client, he couldn't say that she was having ongoing symptoms. At one point he said, I hope she's doing well, and that's why she hasn't come back. So that's what creates the problem. Yes, there were some magic words, but we know from the case law the magic words aren't enough. So that's the conundrum here. If symptoms drive the need for future care, he hasn't seen her, so he can't say whether or not she's having symptoms. That's where the problem comes in, I think.
Absolutely. And the sorry, I had my train of thought and then I lost it. That's always going to be the case, that the symptoms drive it. And that would have been true if he'd examined her 5 minutes before this deposition, because she'd get treated if her symptoms, and then again he would have to give the same testimony.
Well, but the reality is, I'm not. help me on this. If he had said, I have examined Felicia, and I know he said this, she has a permanent condition, and that condition is going to be chronic. It is going to be something that will affect her periodically for the rest of her life. And when it flares up, she will need this treatment. She may be in a stationary position for a few months, and then a flare-up, treatment, stationary, flare-up. I don't think we'd be having this discussion, but he didn't say it that way.
He tied it to the symptoms, I think, is the issue.
Yeah.
He did tie it to the symptoms. In one respect, he tied it to the symptoms and said, this is pain management treatment. If you're not having pain symptoms, you're not going to get the treatment. That's exactly what this treatment is.
Sure.
He's always going to need to examine her, and it's always going to be dependent upon her symptoms. The crucial testimony was, okay, is she going to have these symptoms in the future? That was what was missing from the Griffin case, and that testimony was provided. He expressly said that based upon my examination, the fact that she was still having pain in 2013, we don't see these resolve. He provided his opinion using the magic words that she would need future treatment down the road, and said expressly that he gave a range for how long these injections last for, all the way up to 2 years. So the fact that even if you assume her pain hadn't returned at the time of trial, which it had, that's 17 months, that's less than 2 years, it does not make his opinion invalid. All those things go to the credibility of the evidence, but it doesn't invalidate his opinion. It doesn't mean that the burden of proof was not met, which is exactly what the trial court found based upon the Griffin case. Thank you.
Thank you. Thank you both for your arguments. We appreciate them. We will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned. Thank you.